This video contains excerpts from an online workshop that the US-Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by US-Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
We're going to talk about admissibility, relevance, probative value, prejudice, and the requirement of personal knowledge. They all work together at the same time, synchronously, with respect to the admissibility and the treatment of evidence. Rule 402 in the Federal Rules of Evidence guide the admissibility of relevant evidence. The default position as a general matter is that relevant evidence is admissible unless something makes it inadmissible. We've listed 3 or 4 things here that sometimes make a piece of evidence inadmissible: the Constitution, a federal or state statute, these particular rules of evidence, or some other rule by the Supreme Court. And the last point is irrelevant evidence is not admissible. What do we mean by relevance? Well, if you look at subpart A in this slide, evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. And that's what I touched on earlier. The default position in American trials is that we'll let evidence in if it's relevant. We'll let the fact finder, the jury, sometimes the judge, but we'll let the jury decide. We'll let the jury hear the witness, see the evidence, handle the evidence, consider the arguments of the attorneys. One way to also think of relevance is in contrast to probative value of the evidence. Relevance is static. It's not dynamic. Either a piece of evidence is relevant, in which case it's presumptively admissible, or it's not. Probative value, on the other hand, sort of the qualitative value of that piece of evidence in determining a particular fact, it can be understood as sort of existing on a continuum. So different witnesses, different articles of evidence may be more or may possess more or less probative value depending on a host of issues. Relevance or irrelevance is the blue line, and it is meant to be static. You know, the hat that the bank robber was allegedly wearing in our hypothetical is relevant or not. That's a static question. How probative that hat is will depend on the facts of the case. You know, if it can be connected to the bank robber, then the probative value would be greater. If there's some question, for whatever reason, about whether the bank robber in fact had this particular hat on, then the probative value may not be as great. I wanted to make one other point about the dynamism present in these trials. The hat in our hypothetical, right, and I think Ira mentioned, which has the alleged bank robber's DNA on it, would seem A, to be obviously relevant, and B, to possess significant probative value. On the other hand, that depends. If the witness, say, who saw the bank robber with the hat on can't be found, doesn't show up to the trial, then suddenly the hat has less probative value because there's nobody to connect it to the bank robber. So the point I wanted to make was relevance and probative value work together, but added to the mix is the dynamic nature of these trials. So as Ira said, a witness may come in and testify slightly differently or surprisingly differently even in a case. And suddenly the probative value of a piece of evidence that you thought was one thing may turn out in just a moment to be something else. Assume an issue of consequences, whether identifying the person who robbed the bank. I mean, who is it? Is it the person on trial? Can we positively identify this person as the person who was in the bank? And there are sort of 4 posed questions about different pieces of evidence, which has greater probative value. A lineup, for those of you that are unfamiliar, typically takes place at a police station where you might have 6 or 8 potential suspects. They may resemble one another physically, and a witness will come in and without being tipped off about who the real perpetrator is or who the chief suspect is, pick someone out of a lineup. The probative value of an eyewitness picking a defendant in a lineup, an eyewitness who identified a hat the alleged robber was wearing that fell off his head and that was recovered by the police. There's a video, presumably from the bank, that shows the robber wearing the hat that the police later recovered. And then finally, DNA found on the hat that matched the defendant. As a general matter, I think we would say that number 4, the DNA, may well be the most probative piece of evidence because, as I say in my criminal trials, DNA doesn't lie. It doesn't have friends or enemies. It just is what it is. And if it matches the defendant, the bank robber, then it would necessarily connect him to the hat. But consistent with the point I was trying to make earlier, the DNA on the hat is only as probative, only as important as the witness who can come in and say that he or she saw the bank robber with the hat. And to the extent that that witness is credible, right? That hinges on how probative, the DNA evidence is on the hat. To go back to what we talked about in the first couple slides, relevance, the sort of presumptive admissibility of relevant evidence. There are prohibitions against admitting any relevant evidence. And one of the ways that there's a sort of balancing test is in balancing the probative value with the unfair prejudice that the evidence brings into the case. The rule is 403. The court may exclude relevant evidence if its probative value is substantially outweighed by its unfair prejudice, which would be confusing the issues, misleading the jury, undue delay, waste of time, and so forth. The gate for the admissibility of relevant evidence, though it is wide open, is not wide open always and at all times. There are circumstances where a piece of relevant evidence, because it was substantially outweighed by the unfair prejudice, would not be admitted into the trial. Take the hat from our bank robbery hypothetical. What if the hat, we know, right, that the hat has allegedly DNA from the suspect on it, right? So the probative value is not insignificant. And we have a witness who's going to come in and say, I saw the person run out of the bank and he had on this hat, and they'll describe the hat. But what if the hat had a logo on it? What if the hat had something printed on it? Well, whatever the logo was might help the witness identify the hat, make that witness more credible. I'll never forget it. It had such and such a design on it. But what if that design, just by virtue of the design, was somehow arguably prejudicial? So what if the hat had an NYU Law School logo on it? What if the hat had a cop killer logo, like that it carried some distasteful message, or at least potentially distasteful to the jury? Would that be enough unfair prejudice to keep the hat, which is relevant, out of evidence? What if it was a New York Yankees logo, but you were a New York Mets fan? What if it was a Bernie for president hat and not a Make America Great Again hat? I mean, these things would go into the consideration that a judge would make if the lawyers made the argument that, yes, I agree, the hat is relevant. However, because it has a original gangster cop killer logo on it, my client is African American. He's going to be associated with this kind of behavior, but he's presumed innocent. The unfair prejudice outweighs the probative value of the hat, and the hat should be excluded.
I just want to point out there is an intermediate position on the hat. It's possible that the hat could be admitted into evidence, but the logo would be concealed from the jury because the logo would be found to be prejudicial. And that creates some problems, but in the balancing test, sometimes a portion of the evidence might be redacted or covered up, hidden from the jury because it's unfairly prejudiced. So I just wanted to make sure we were clear that you wouldn't necessarily lose the probative value of the hat just because it had a prejudicial logo on it. A judge might balance that, find the balancing in a way that is a compromise.
Well, all right, thanks. That's a good point, because it goes back to what we talked about at the beginning of this session, which is the default position is to admit the evidence. So it's not an all or nothing proposition. It's not necessarily, anyway, that the hat comes in or it doesn't. If it's an important probative piece of evidence, the court may decide, well, we'll let in the hat so that the DNA evidence comes in, but we're going to put tape. I mean, that could literally, something like that could literally happen. We'll put tape, masking tape, over the logo on the hat. I'll give you another quick example. Let's say when the police showed up to interview the eyewitness, the person who said he saw the bank robber, he may say something like, he's not going to say, I saw the bank robber come out of the bank. He's going to say something like, I saw the blank, blank, blank person come out of the bank. And whatever he happens to say in his excitement, may not be the most tasteful, polite thing to say about the person who robbed the bank and may have scared him. At trial, even though the way he described the bank robber may be not polite, distasteful, something you wouldn't necessarily want to repeat, the judge may say, well, I'm going to let in the identification, but I'm going to ask the witness not to repeat some of the words he may have used to describe the bank robber, because those would be overly prejudicial to the defendant. There are a host of rules, 404, 05, 06, 410, listed here, that do put some constraints on blanket admissibility of relevant evidence. Rule 404, character evidence, crimes, or other acts. We typically do not, in American criminal trials, admit evidence of prior misconduct that is similar to the charged conduct. So for example, in our hypothetical about the bank robber, if this guy's a professional bank robber and he's been charged and convicted in a dozen other cases for very similar bank robberies, is that relevant? Yes, it's relevant. This is a guy who seems to make his professional life robbing banks. But even so, he's on trial for this particular bank robbery. And absent other special circumstances, the fact that he's robbed banks in the past is not admissible, because essentially the argument is that it is unfairly prejudicial, Rule 403, which we talked about earlier, to his current trial for bank robbery.
Just want to clarify, when we're talking about the federal rules of evidence, obviously we're talking about a system where there's a jury trial. And what admissibility would mean is evidence that's admissible means the jury is allowed to hear that evidence. And if a judge rules evidence is not admissible, the jury wouldn't hear that evidence at all. When you're having a judge trial, it's a little bit different. Obviously, the judge is going to be aware of the inadmissible evidence, but the judge would make a ruling that she would not base her decision on inadmissible evidence. So I think even though these rules are designed for a jury system, the same principles could apply to a judge trial, and do apply, because we do have cases where the defendant waives their right to a jury trial. And we also have hearings where the rules of evidence apply.